Ed Paltzik, Litigation Counsel for the Second Amendment Foundation of Counsel at Taylor Dykema. Ed, welcome up. You can use this, or you can use the standalone, whichever might be more. Yeah, you absolutely can. Here you go. Oh, there you go.
Thank you.
It's already hot.
Thank you. Good morning, everyone. I want to thank my friends, Adam and Bill. I want to thank SAF. I want to thank my colleagues, Meredith Lloyd and Serge Krimnis, who are in the audience, who have fought so hard for the Second Amendment. And I want to thank you all for listening. So today's topic is guilt by association, right? So you're not disqualified, but your family member is. Now, we heard the word temporary, but it's not always someone who's temporarily disqualified. It could be a felon, right? Now, we have temporary disqualifications, like someone who just got red flagged, which is becoming more and more topical every day, right? We have maybe your family member's been committed, right? Sometimes the standards at the state level are more rigorous than the federal standards under 922G, right? And there are just so many different disqualifiers. And the problem that we have today, and this is a very underreported problem, but a very significant one, is that local law enforcement, local prosecutors, they are arbitrarily confiscating firearms, ammunition, and accessories. They're confiscating your property because of who you live with. This is a problem that is flying under the radar, and it's a big one. And it's a very big problem in particular because a lot of times the confiscation is not even based on a particular law. Sometimes the prosecutor will inform the individual who's the subject of this action, well, the state has concerns. Actually, that just happened to one of my clients who shall remain nameless. We'll refer to him as husband and we'll refer to his wife as wife. But they told him the state has concerns. And when I asked the prosecutor if he could provide a legal citation, case law or statutory, for the confiscation and retention of the firearms, he couldn't. So I'm going to share with you two little stories, two little vignettes, and then I'm going to move to policy, what we can do about this, and what are the problems associated with this. So it's story time now. So gather around for two little stories. Story number one is the computer programmer. So the computer programmer lives with his wife in Fort Lee, New Jersey. Wife is not feeling well one day. She's feeling a little depressed. She's feeling physically ill. She's pregnant. Entirely normal. She goes to a clinic, have herself checked out. During the course of her examination, they ask her how she's feeling. She says something to the effect of, "Ugh, I feel like I want to die." Now, this is just a figure of speech. This is the English language, right? People talk like this all the time. She didn't say, "I'm going to kill myself." She didn't say, "I'm going to kill someone." But of course, under New Jersey's duty to warn law, this triggered an obligation for the medical provider to report her. So this was in Englewood, New Jersey. So they inform Englewood police, okay, we have someone who might be suicidal. Englewood police respond and they take her in for an involuntary admission at Newbridge Medical Center. Okay. She's there for 3 days. Predictably, she was released, and there was, of course, it's in the medical record, she's not suicidal. No suicidal ideations, nothing. We're not dealing with, schizophrenia, nothing like that. There's a notation, just says, she's depressed, she's pregnant, just pregnancy depression, essentially, the diagnosis. She's released, she's fine, she's been fine. Englewood police, though, at the time, they then call Fort Lee police. Fort Lee police then show up at the house and husband answers the door, the computer programmer. They say, do you have any firearms? Do you have any ammunition? He says, yes. He has 2 handguns and a rifle. He has his ammunition. He has accessories. And they tell him, sir, you have to surrender your property right now. Obviously, you don't have much of a choice. Surrender to the state's show of force, as SCOTUS tells us, is a seizure within the meaning of the Fourth Amendment. And of course, we have all kinds of issues with these cases. We have Fourth Amendment issues. We have Fifth Amendment issues. Obviously, it's a Second Amendment issue, but we've got multiple amendments. There may also be First Amendment issues here relating to speech and, what you say to a medical provider and all that. All right. So they take the property, they take his constitutionally protected property. He then engages in a email exchange, a little dialogue with a paralegal at the Bergen County Prosecutor's Office. And he's given the following options. He can consent to the destruction of his firearms. He can arrange for a sale of the firearms, or he can have a hearing, but it'll take 6 months. Then we have a 14th Amendment issue as well. We have due process issues here. You can see the horrible issues. So he begins to realize that his rights are being violated, but he still doesn't have counsel. Finally, he gets into a dialogue with one of the prosecutors, who again is forcing this hearing on him. Now they say, look, maybe the state will be satisfied if you turn over her medical records. Otherwise, we're going to have to revoke your firearms purchaser identification card. So it's total coercion. So finally, he decides he's not going to give in to this, and he's not going to turn over the medical records because it doesn't matter what her condition was. He's the firearms owner. She doesn't own the firearms. Why does he have to comply with this? So I got involved. As I said before, I said to the prosecutor, hey, can you just cite for me the statutory authority for this? Is there a case? So instead of giving me the authority, he just responds the next morning with a motion to revoke husband's firearms purchaser identification card. So we're going to be going to federal court, District of New Jersey on this, while we also deal with the state level issues. So that's crazy. The second story, which is much shorter, is the lieutenant colonel, retired lieutenant colonel, United States Army. His son, his teenage son in high school, got red flagged over nothing. He was talking on the school bus with one of his friends, relaying some secondhand threat that another classmate had made. He said, hey, did you hear about Johnny? Johnny made some kind of threat. School initially suspends him. Then they realize he didn't do anything wrong. He wasn't the one who made the threat. No problem. He's reinstated. He's back in school. He's on campus. Everything is great. Not so fast. Local police show up to the house a week later, and they tell the lieutenant colonel, we're taking everything. And he had a huge collection, antiques, fancy rifles, great stuff. They take it all. We get involved, and we actually had to do a hearing up in Buffalo. There's a New York law where you actually have to prove that you're the owner of the confiscated firearms. So even though the police took the firearms out of your house and they vouchered them, you then have to prove that you're the owner to get them back. So he goes through this multi-month disqualification period because his son had been red flagged. Eventually, we get the firearms back, but of course, the cost is massive. The legal fees, the time, it's all more than the value of the firearms themselves. So we have these two stories. Now let's put them off to the side and talk about what we can do about this, right? So, and this is really insidious, right? Because at bottom, what's the most common disqualifying category? It's not felon, it's not mental illness, it's not fugitive from justice, it's not being under a restraining order. It's actually being a child. And, most of us live with children. So, right, the logic, well, you live with someone who might be mentally ill or they were committed. The logic can extend to children, and you see how this can just mushroom out of control. In theory, well, we can't have firearms in any house with children. Well, they're disqualified individuals in a sense, right? So the other issue, though, is this has to be addressed through as applied challenges, which makes it a little bit harder. There is no facial challenge that's just going to knock this all out in one fell swoop. Eventually, look, perhaps this could get to Supreme Court or a U.S. Circuit Court of Appeals. It's possible. But prosecutors are often not even relying on a particular statute or a particular case. They're just doing it. So you have this arbitrary seizure and then this arbitrary retention, this deprivation, and you're just challenging the arbitrary action. So in order to combat this scourge, it's going to have to be accomplished through a series of as applied challenges all throughout the country. And, you know, eventually you establish some good law. And at the end of the day, again, keep in mind, don't go for the head fake. Don't go for the red herring, the smoke and mirrors. They'll say, oh, well, you know, what about this mental illness and that mental illness? None of that should matter because the principle here is very simple. You shouldn't be disqualified because someone in your household is disqualified. So what are the remedies? So I want to talk about three remedies, three ways to look at this situation and how we can make it better, okay? So one of those remedies is influence, the word influence, okay? Now, the Supreme Court, this was not in this context per se, but in the context of a felon making a motion to transfer, to sell his firearms after a felony conviction, the Supreme Court said, a court may grant a felon's request to transfer his guns to a person who expects to maintain custody of them so long as the recipient will not allow the felon to exert any influence over their use. And that's really the touchstone here. Just because someone's in your household doesn't mean that they're exerting influence over your firearms, okay, or your ammunition, right? Number two, tort law. Okay, and by the way, that case, the Supreme Court, that's a case called Henderson v. United States, 575 U.S. 622, 2015. Okay, number two, we move, and I have a little over 2 minutes left. We move to tort law, right? Civil liability. An example, a Michigan Court of Appeals in a case called Lito v. Monroe, 273 Mich. App 416 in 2006. They said, we find that an individual gun owner who leaves a weapon in a location accessible to a convicted felon, but has no reason to foresee the felon's misuse of the weapon is not civilly liable, right? So that's relevant principle number two. And then finally, in the minute and a half we have left, we come to what I think is the most important argument. Okay, I'm going to use New York State Penal Law 265-45 as an example. This is New York State's safe storage law. Now, I will say on a personal level, my personal opinion, which doesn't matter very much, but I am staunchly opposed to any quote unquote safe storage laws, but they actually serve a purpose for this one issue. Because there's a simple argument by analogical reasoning here, by analogy, right? This New York State Penal Law 265-45, just an example of one such state law. It essentially says, in sum and substance, no person who owns or is a custodian of a rifle, shotgun, or other firearm, and who resides with an individual under the age of 18, someone who is under an ERPO, right? Someone who's been red flagged, right? Whatever they call them, gun violence, restraining orders, all these ridiculous names. Or someone who has been disqualified under 18 USC 922G, the various factors, right? And it also says if you live with a felon, you are required in New York to lock up your firearms, either using a device that disables the weapon or put it in a safe. And in the last 10 seconds, I'm going to say this. If there's a law that specifically deals with how you're supposed to store and safeguard your firearms in the presence of a disqualified family member, well, obviously, by implication, that means you are allowed to have those firearms in the house with those people. The statute doesn't say, well, you can't have the firearms. So, reasoning by analogy. Last thing I'm going to say is I want everyone to carefully consider this issue and think about its importance, because again, it's in the shadows, but it's creeping out of the shadows and it's going to become a bigger issue. I want to thank you for listening today. Thank you.